What are international human rights? Let's lay the foundation. Examples of human rights can be found dating back to the Code of Hammurabi and to the Magna Carta. But the more recent, modern corpus of human rights evolved in the 18th century with the Age of Enlightenment and with the drafting of the US Constitution, Bill of Rights, the French Declaration of Rights of Man and Citizens. Many of these principles in these early documents influenced the creation of the modern international human rights system, which began in earnest after the atrocities of World War II and with the founding of the United Nations in 1945. The Declaration on the Essential Rights of Man was a principal document proposed at the 1945 San Francisco Founding UN Conference. Early on in the process, the document was split into declarations setting forth principles of human rights and a convention or covenant containing binding commitments. The former evolved into the Universal Declaration of Human Rights and was adopted in December 1948. There's now, in current day, this has evolved into a complex system of different forms of treaties and conventions that govern international human rights. The two main differences between these different treaties and conventions is there's UN charter-based systems, this is the UN Declaration of Human Rights, and there's treaty-based systems. These are the ones you see on the slide: International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights. Together with the Universal Declaration of Human Rights, is oftentimes referred to as the International Bill of Human Rights. There are 9 principal core treaties on international human rights. The first two I mentioned, the ICCPR, International Covenant for Civil and Political Rights, and the International Covenant for Economic, Social, and Cultural Rights. The other principal treaties are the International Convention on the Elimination of All Forms of Racial Discrimination, Convention on the Elimination of All Forms of Discrimination Against Women, Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, Convention on the Rights of the Child, International Convention on the Protection of Rights of All Migrant Workers and Members of their Family, and International Convention for the Protection of All Persons from Enforced Disappearances, and the Convention on the Rights of Persons with Disabilities. The ICCPR, the International Covenant for Civil and Political Rights, was adopted by the UN General Assembly in 1966. It's important to note what it covers as opposed to what some of the other treaties cover. Article 1 provides all people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. It also provides all peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation. This principle of the right of self-determination is in both the ICCPR and the ICESCR. Article 6 of the ICCPR says, every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. Article 7, no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Article 9, everyone has the right to liberty and security of person. No one shall be subjected to arbitrary arrest or detention. There's a number of more rights. There's 30 articles in the ICCPR. The ICESCR, on the other hand, slightly different. Article 7, for example, the right of enjoyment of just and favorable conditions of work. Article 11, the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvements of living conditions. Article 13, the state parties to the present covenant recognize the right of everyone to education. Much different rights between these two different covenants, and it's important to note that difference. How are human rights, international human rights, enforced? How are they monitored? How do they differ from national human rights? You think of the courts and system in your country. If someone violates your rights or violates a law, you can take them to court. The international human rights system doesn't quite work that way. It's a little bit different. There's a number of different monitoring bodies. The UN Commission on Human Rights was established in 1946, eventually became the Human Rights Council in 2006. Its main functions are it conducts a universal periodic review, which assesses the human rights situation in all UN member states. It runs a complaint procedures, which allows individual and organizations to bring human rights violation concerns to the attention of the Council. Council can produce an opinion on those. The Office of the High Commissioner of Human Rights was established in 1993 to provide further support to the international human rights system. It's within the UN Secretary General Office. It supports treaty bodies in enforcement, supports special rapporteurs and independent experts on human rights topics. Those are the main bodies within the UN Charter. They're more involved with enforcing the UN Declaration on Human Rights. But each treaty, the ICCPR, the ICESCR, some of the other ones I mentioned, CEDAW, those all have specific treaty committees that are charged with monitoring and enforcing implementation. Different treaties in different international law contexts have different enforcement mechanisms. Some treaties will incorporate an arbitration tribunal within their enforcement mechanisms. The human rights treaties typically all have a committee of some sort that reviews individual cases, reviews complaints from states, and produces opinions or reports. However, states are more likely to fear tactics used by other states as a result of reports on their human rights violations, such as reciprocity, collective action, shaming. I want to make a brief mention of two other court bodies that you've probably heard of, the International Criminal Court and the International Court of Justice. These aren't quite so as relevant for the international human rights discussion we'll be having here. The ICJ, International Court of Justice, is a body at The Hague in the Netherlands where states can bring other states to the court for violation of international law. The ICC, the International Criminal Court, has a specific jurisdiction over war crimes, genocide, crimes against humanity, much narrower mandate, and it can prosecute individuals for those violations. However, the ICC is not signed by all countries. The US has not signed it, has not ratified it. So it's not always as important of an institution in terms of human rights enforcement. Another important part of the international human rights system to talk about and to consider is regional human rights systems. A number of regions, including the Organization of American States, OAS, the European Court of Human Rights, and the African Court of Human Rights, have developed their own charters, their own human rights instruments, and then developed relatively strong enforcement mechanisms for those human rights. The European Convention on Human Rights was one of the first and was started in 1950. Defined and guaranteed human rights and fundamental freedoms in Europe. All 47 members of the Council of Europe have signed the convention, and the European Court of Human Rights in Strasbourg has jurisdiction over all those states. The Inter-American Commission on Human Rights is an autonomous organ within the Organization of American States, the OAS, in Washington, D.C., and it, along with the Inter-American Court of Human Rights based in San Jose, Costa Rica, is one of the bodies that comprises the Inter-American System for Promotion and Protection of Human Rights. These are permanent bodies with specific mandates and jurisdictions. It's important to note that there is no Asia-specific human rights mechanism either. Now that we've looked at some of the details on human rights and international human rights systems, institutions, let's talk about where land falls within international human rights. Land has not quite as clear of a position in a lot of international human rights treaties as other issues. But it's important to look at where that comes from. In the 18th century US Bill of Rights and the French Declaration on the Rights of Man, the protection of property rights was actually at the same level as the right to life. The Universal Declaration of Human Rights in Article 17 actually discusses a right to property. It states, everyone has the right to own property alone as well as in association with others. 2, no one shall be arbitrarily deprived of his property. However, when the ICCPR and ICESCR were drafted, there's no explicit discussion of property rights or land rights. The ICCPR Article 27 discusses cultural rights for minorities. The ICESCR Article 11 discusses right to adequate standard of living and food and housing. And then subsequent conventions, the ICRD Article 5 talks about prohibiting racial discrimination, guaranteeing the right to own property alone as well as in association with others. CEDAW talks about eliminating discrimination against women on topics touching land and equal ownership of property, equal benefit to rural development. It's important to discuss another international document, human rights document, the International Labor Organization's Convention number 169. It's a legally binding instrument open to ratification, which deals specifically with the rights of indigenous and tribal people. It's ratified by 22 countries, most in Latin America, Spain, Norway, the Netherlands, Nepal. It identifies criteria for describing the indigenous and tribal people it aims to protect, but allows for self-identification by these groups. ILO number 169 also provided for consultation for indigenous and tribal people on issues that affect them. It established certain principles that requires that people are able to engage in free, prior, and informed participation in policy and development processes that affect them. This is also called FPIC. It's a commonly cited principle in ILO 169, but also in the UN Declaration on the Rights of Indigenous People. There is some debate in the international community over the use of FPIC and the degree to which it applies to consultation or consent. Further examples of land in the international human rights system include the regional human rights bodies and charters. The American Convention provides in Article 21 the right to property. Everyone has the right to the use and enjoyment of his property. The law may subordinate such use and enjoyment to the interest of society. The African Charter provides in Article 14 the right to property shall be guaranteed. It may only be encroached upon in the interest of public need or in the general interest of the community and in accordance with the provisions of appropriate laws. The European Convention on Human Rights, Article 1, Protocol 1, provides for the right for natural and legal persons to peaceful enjoyment of his possessions, subject to the general interest or to secure the payment of taxes. The language on general interest that you see in both of these articles is important to take note of because we'll discuss that in the future in subsequent slides. Cases relating to the protection of indigenous peoples at the regional level has been litigated before the UN Human Rights Committee in the 90s, but it was not until the year 2000 that the first legally binding decision by an international tribunal upheld the collective land and resource rights of indigenous people. Let's talk briefly about the voluntary guidelines on the governance of tenure. It's an important distinction to look at international treaties, human rights instruments, and guidelines such as the voluntary guidelines on governance of tenure. The voluntary guidelines are not international law, it's not binding, but it can help inform states on the proper policies in relation to land governance and tenure. There's 5 important principles to look at within the voluntary guidelines. Recognize and respect legitimate tenure rights, safeguard tenure rights against threats, promote and facilitate the enjoyment of tenure rights, provide access to justice when rights are infringed, and prevent tenure disputes and violent conflict. The voluntary guidelines in different parts talks about certain steps and considerations for states in protecting tenure. Part 3 provides for legal recognition and allocation of tenure rights and duties, addresses the legal recognition of tenure rights of indigenous people and other communities with customary tenure systems. Part 4 discusses transfers and other changes to tenure rights and provides guidance for when tenure rights are transferred, changed in various ways. Part 5 discusses administration of tenure, covers administrative aspects of effective governance of tenure. Part 6 discusses climate changes and emergencies. And Part 7 promotion, implementation, monitoring, and evaluation around land tenure governance.